I can't quite believe that I'd forgotten about this particular portion of the performance that was Amber Heard's testimony in the Virginia trial. But all thanks to Ben Shapiro and his team for pointing this out in a recent video, that it's brought it back to my attention and I just had to share it with you. So you'll remember that Amber Heard was giving testimony in court in Virginia, and at various times she had a tissue in hand, doubtless because they will say that she was very upset by the testimony. However, watch this very short clip and then let me know what you think in the comments.
And after you both returned to LA.
Now you'll notice when you pay attention to the detail, because that's what I tend to do, I will pay attention to that detail, that as she brought the tissue up to her face, there was a momentary glance to her left-hand side, which is where the photographers were positioned, just behind the lawyers' desks, facing the witness boxes. Just as she glanced over towards those photographers, she paused and she held the tissue to her face, and in my view, of course, quite conclusively, she was posing for a photograph. She was literally posing for a photograph with the tissue held to her face, as if to show the world media that she was particularly upset by this event. Now this is of course in no way to detract from how upsetting giving evidence can be. I'm sure it was. It's upsetting for anybody, regardless of whether you're telling the truth or not. However, this, in my view, and you could make your own mind up based on the clip that you've just seen, in my view, this was blatantly an attempt to get a photograph of her holding a tissue to her face so that this could be put out in the world's media to show how upset she was giving evidence on the stand. However, let's not forget, by contrast, as highlighted by Ben Shapiro and his team, the audio recording of when Amber tried to distinguish between a hit and a punch and a slap, where she said to Johnny Depp that she wasn't punching him, she was hitting him, and making the distinction in her terms, as heard in the audio recording, as to whether or not she was actually hitting him or punching him.
I'm sorry that I didn't hit you across the face in a proper slap, but I was hitting you. It was not punching you. Babe, you're not punched.
Now I think this is important to keep in mind when thinking about the context of Amber Heard's recent statement on Instagram following the settlement of this appeal. Because she says, after a great deal of deliberation, I've made a very difficult decision to settle the defamation case brought against me by my ex-husband in Virginia. Now, first of all, it isn't settling the whole of the defamation case because the jury verdict stands. Secondly, I don't think it's really a difficult decision considering the insurance company are going to pay the $1 million as opposed to the $10 million that was awarded by the jury, so I don't think that's a difficult decision anyway. And then she goes on to say that it's important for me to say that I never chose this. I defended my truth, and in doing so, my life as I knew it was destroyed. Taking the first part of that statement, important for me to say that I never chose this. Chose what? The settlement or the entire case? Well, let's take them both in turn. First of all, she says that she never chose this. Let's say that she means the settlement. Well, in that sense, she might be right. It might be that the insurance company said, you must accept this, otherwise we're not going to fund anything. Because there's probably a term in their terms and conditions that says, if you don't accept a settlement that we think is reasonable, then we are not going to fund anything. Because most insurance companies do have that policy within it. If you don't accept a reasonable offer of settlement, and then you go on to trial and lose or don't achieve a settlement that's as good as the one that was given to you, offered to you in the first place, the insurance company might quite rightly say, well, that's your problem and you are on the hook for all of that. So potentially that might be the case. Maybe she didn't choose this. Maybe it was the insurance company that imposed this upon her because they might have said, well, this is an offer we just simply can't refuse. 1 million as against 10 million. But let's say that, in fact, she's talking about the entire case. Maybe she didn't choose the entire case. Well, in that sense, I have to respectfully disagree, because she wrote the initial article that said he abused her, which ultimately, as decided by a jury, turns out he didn't, and she lied about it, according to the jury. Everybody saw the trial, everybody heard the testimony, everybody heard about the jury verdict, in which they decided she wasn't telling the truth, and in fact, he didn't do so after all. But then moving on to the second bit of that statement, when she says, "I defended my truth, and in doing so, etc., etc." Well, whenever someone refers to my truth, as opposed to the truth, because the truth is a universal concept. My truth would be your truth, would be someone else's truth, if it is the truth, as in literally what happened truthfully. So for me, when she uses the words my truth, that to me, as many of you commented to my previous video, suggests that it's her version of events and not anyone else's, and not necessarily the truth. But I can leave you to be the judge of that for yourselves. And then of course she goes on to talk about the UK trial once again, because of course that, albeit she wasn't a party, she says that was an impartial and fair system, where she was protected from having to give the worst moments of her testimony in front of the world's media. Now, perhaps she was referring to the bits that were in the confidential annex, or perhaps she was referring to the fact that she was not a party to the proceedings and therefore not subject to the same disclosure rules as everyone else that was a party to the claim. Because of course she was protected from having to give what potentially could have been the worst parts of her testimony by choosing what evidence she would give and when she would give it within that trial. Albeit she sees it that she was protected, whereas by contrast she says that in the US she was subjected to a courtroom in which abundant direct evidence that corroborated her testimony was excluded. Now, bearing in mind that a lot of the evidence that she most probably refers to was hearsay evidence that was previous consistent statements, which was not necessarily direct evidence of the truth, only evidence of what she said to other parties. Nonetheless, she was subjected to a courtroom and she was subjected to direct evidence, in which the jury ruled unanimously against her. And finally, she concedes that even if the US appeal is successful, the best outcome would be a retrial where the jury would have to consider the evidence again, and that she simply couldn't go through it a third time. Now, I accept that she probably wouldn't want to go through it a third time, albeit in a very different context, because the first trial in the UK was not the same as it was in the US. But as I said at the outset of this video, you have to take all of that in the context of someone that is prepared to pose for a photograph with a tissue to her face to attempt to show the world's media that she was upset during this trial. So like I say, credit to Ben Shapiro and his team for picking that up. I'd clean forgotten about that bit because I'd been focusing on the legal details and the analysis of the evidence. But I hope you found that interesting. Please do put that into context with everything else. Please do remember to like this video and subscribe if you would like more cases covered like this one. Let me know in the comment section below and I will come back and do exactly that. In the meantime, thank you for watching.